This video is only for remembering keywords, not for understanding the topic from scratch. It's meant for students who already know the concept. If you find a mistake, let me know.
Application for registration. Registration of a firm may be effected at any time by sending by post or delivering to the registrar of the area in which any place of business is situated or proposed to be situated. A statement in the prescribed form and fee stating 1. Firm's name. 2. Place or principal place of business of the firm. 3. Names of any other places where the firm carries on business. 4. Date when each partner joined the firm. 5. Names in full and permanent addresses of the partners. And 6. Duration of the firm. Statement shall be signed and verified by all partners or by their agents authorized. A firm name shall not contain any of the following words, namely, crown, emperor, empress, empire, imperial, king, queen, royal, or words expressing or implying the sanction, approval, or patronage of government, except when the state government signifies its consent to the use of such words as part of the firm name by order in writing. Registration of firm. Registrar is satisfied then, record an entry of the statement in Register of Firms and file the statement, and issue certificate of registration. Effective date. Registration is deemed to be completed as soon as an application in prescribed form, fee, and necessary details of partnership is delivered to registrar. Recording of an entry in the Register of Firms is a routine duty of registrar. Registration may also be effected even after a suit has been filed, but in that case it is necessary to withdraw the suit first, get the firm registered, and then file a fresh suit. Late registration on payment of penalty. If the statement is not sent or delivered within the time specified then, firm may be registered on payment of penalty of 100 rupees per year of delay or a part thereof. Consequences of non-registration. Registration of firms is not compulsory as per Indian Partnership Act, yet the consequences or disabilities of non-registration are 1. No suit in a civil court by firm or other co-partners against third party. The firm or any other person cannot bring an action against the third party for breach of contract entered unless the firm is registered and the persons suing are or shown in the Register of Firms as partners in the firm. 2. No relief to partners for set-off of claim. If an action is brought against the firm by a third party, neither the firm nor partner can claim any set-off if the suit be valued for more than 100 rupees. 3. Aggrieved partner can't bring legal action against other partner or the firm. Partner of an unregistered firm is precluded from bringing legal action against the firm or alleged partner or have been a partner in the firm, may sue for dissolution or for accounts and realization of his share when firm is dissolved. 4. Third party can sue the firm. Action can be brought against the firm by a third party. Exceptions. Non-registration of a firm does not affect the following rights. 1. Right of third parties to sue the firm or any partner. 2. Right of partners to sue for dissolution or settlement of accounts or for realization of property. 3. Power of an official assignees, receiver of court to release the property of insolvent partner. 4. Right to sue or claim a set-off if the value of suit does not exceed 100 rupees in value. 5. Right to suit and proceeding instituted by legal representatives or heirs of the deceased partner of a firm for accounts of the firm, or to realize the property of firm. Dissolution of firm. Dissolution of partnership between all partners of a firm is called the dissolution of the firm. Dissolution of firm means the discontinuation of the legal relation existing between all the partners of the firm. Mode of dissolution of court. Without court intervention or voluntary. 1. Dissolution by agreement. Dissolution by agreement with the consent of all partners or subject to contract between partners. 2. Compulsory dissolution. By happening of any event which makes it unlawful for the business to be carried on or for the partners to carry on partnership. Note, if there are one or more than one separate adventure or undertaking, illegality of one or more shall not cause the dissolution of firm in respect of its lawful adventure or undertakings. 3. Happening of certain contingencies. Subject to contract, firm may dissolve on 1. If firm is constituted for fixed period, then on expiry of fixed term. 2. Firm is constituted to carry one or more adventure, then on completion of adventure or undertaking. 3. By the death of a partner and 4. By the adjudication of a partner as insolvent. 4. Dissolution by notice of partnership at will. By any partner giving notice in writing to all other partners stating intention to dissolve the firm. Date of dissolution mentioned, then the firm is dissolved on the same date as mentioned. And if no date is mentioned, from the date of communication of notice, with court intervention. A. Insanity/unsound mind. Where a partner, not a sleeping partner, has become of unsound mind, the court may dissolve the firm on a suit of the other partners or by the next friend of the insane partner. Temporary sickness is no ground for dissolution of firm. 2. Permanent incapacity. When a partner, other than the partner suing, has become permanently incapable of performing his duties as partner, then the court may dissolve the firm. May result from physical disability or illness, etc. 3. Misconduct. Where a partner, other than the partner suing, is guilty of conduct which is likely to affect prejudicially the carrying of business, the court may order for dissolution of the firm. By giving regard to the nature of business, it is not necessary that misconduct must relate to the conduct of the business. Important is adverse effect of misconduct on business. 4. Persistent breach of agreement. Where a partner other than the partner suing, willfully or persistent breach relating to management or conduct or matters relating to business that it is not reasonably practical to carry on business. Following comes into category of breach of contract. Embezzlement, erroneous account, holding more cash than allowed, refusal to show accounts. 5. Transfer of interest. Where a partner other than the partner suing transferred interest wholly or allowed share to be charged or sold by court in recovery of arrears of land revenue. 6. Continuous perpetual losses. Where the business of the firm cannot be carried on except at a loss in future also, the court may order for its dissolution. 7. Just and equitable grounds. Where the court considers any other ground to be just and equitable for the dissolution of the firm, it may dissolve a firm. The following are the cases for the just and equitable grounds. 1. Deadlock in management. 2. Partners are not talking. 3. Loss of substratum object. 4. Gambling, consequences of dissolution. 1. Liability for acts of partners done after dissolution. Partners continue to be liable for any act done by them before dissolution unless public notice is given. Exception. No liability even where notice of dissolution has not been given in case of 1. The estate of a deceased partner. 2. An insolvent partner. Or 3. A dormant partner. 2. Right of partners to have business wound up after dissolution. Every partner or his representative is entitled to have property of firm to be applied in payment of debts and liabilities of firm, and to distribute surplus according to their rights. 3. Continuing authority of partners for purposes of winding up. After dissolution, authority of partner to bind the firm continues as necessary. 1. To wind up the affairs of the firm, and 2. To complete transactions begun but unfinished. Provided firm is in no case bound by acts of an adjudicated insolvent, and it does not affect liability of partner by estoppel, who represented or allowed to be represented as a partner of the insolvent partner. 4. Mode of settlement of partnership accounts. Following rules shall, subject to agreement, be observed. Losses, including deficiencies of capital, shall be first paid out of profits, next out of capital. Lastly, if necessary, partners individually in proportion profit sharing. Assets, including deficiencies of capital, must be applied in the following manner. 1. In paying the debts of the firm to third parties. 2. In paying to each partner due to him from capital, advances. 3. In paying to each partner due to him on account of capital, and 4. Residue, if any, shall be divided in proportions of profits. 5. Payment of firm debts and of separate debts. If there are joint debts due from the firm and also separate debts due from partner, property of firm shall be first applied to payment of debts of firm, surplus, if any applied to partners, separate debts of paid to him. Separate property of partner first applied to payment of his separate debts and surplus, if any, payment of debts of the firm.
If this helped you remember the provision, hit like, share it with your classmates who need it too, and subscribe. I'll upload a law provision every day. See you tomorrow.